Good afternoon, everybody. My name is Kim Smith, and I'm an elder law and estate planning attorney in the Melville area. I'm going to speak to you today about basic estate planning and documents and how important they are. In light of the pandemic and what we've been going through as a country, it is more important than ever to have a plan in place, and most importantly, some estate planning documents. Estate planning documents are documents such as directives, healthcare proxy, living will, power of attorney, wills, your last will and testament, and often trusts can be part of that estate plan. The most important documents to me, which I will begin with, are the directives, namely the healthcare proxy. So, what is a healthcare proxy? A healthcare proxy is a document that appoints an individual to make healthcare decisions for you if you're not able to make them yourself. It can only be one person at a time. You could have a successive list of individuals to act in the order of preference, but you cannot have two agents acting at the same time. And the reason for this, and it's practical, is that if you have two people appointed at the same time, if they have a conflict in opinion over what your medical needs should be, there could be a stalemate in the treatment or performance of medical care for you. So by having only one person appointed at a time or one person with the authority, that individual's word or decision will be followed. You should pick the individual that is most appropriate for that role. And what I mean by that is, if you're choosing children rather than a spouse, you would not choose your child merely because they were the oldest child, and they would be insulted if they were not appointed. If that child would not be, adult child, would not be able to make a proper decision for you, then that's not the individual that you want to appoint. You know, for instance, my oldest son is very nervous, would never be able to disconnect me from life support, and would have a really hard time, heart of gold, but a really hard time making a medical decision for me. So just because he's my oldest is not a reason to put him in that place. I would choose a different individual to do that for me, to have that role. Healthcare proxy is only affected if you become incapacitated and are not able to make medical decisions. If that does occur and then you regain capacity, then you are able to again make your own decisions. Extremely important document, especially with all the sick individuals with this virus. Some have been put on life support and such, and may have been out of it for a time, and would need someone to make medical decisions for them. And hopefully, upon coming off the life support and recovering, they're able to then make their own decisions. The living will is what goes hand in hand with that. And what the living will is, it's direction to the agent that you appointed in the healthcare proxy as to what your end-of-life decisions would be if you were basically in a coma and had no chance of recovery. So the items that it would outline would be things like feeding, hydration, and life support if you wouldn't want that if you were in a certain state. Now obviously in the example I just used, currently with being on respirators and such as a result of this virus, we would want to be on those machines because there is a chance of recovery. The living will is more specific to somebody that's not going to cognitively ever regain consciousness again. So the living will I normally draft in a separate document than in the healthcare proxy like the state form has, because when I go to the hospital, I want the physicians and the medical staff to do everything to save me, and I don't want it to be a limitation, my living will to be a limitation, where they say, well, she said if this circumstance happens. That document, the living will, is specifically for your agent, the person you appointed in your healthcare proxy, to know what your wishes are. It's not direction to the facility or institution where you may be. So to me, those obviously are the two most important documents to have in place. The next directive is called a power of attorney, and this is a little bit more complicated in that a power of attorney is a document that enables someone to handle finances for you. So they would be able to do banking, file tax returns, perhaps create trusts, open bank accounts, contact insurance companies to get information for you. These are things that you would want an individual to be able to do if you were not able to do them yourself. Because the powers are very expansive, there is risk for financial exploitation if you appoint the wrong individual to act on your behalf. In 2009, 2010, laws were passed to protect the individual who drafts a power of attorney or executes a power of attorney, to prevent them from financial exploitation. And what they did was they added a nice warning in the document. They listed that you can appoint a monitor, which is an individual to oversee who you appoint in the document. The individuals that you appoint as your agents under a durable power of attorney actually have to sign agreeing to act and agreeing to keep the assets separate and apart. So in other words, if one of my children were managing my assets because I was unable to, they could not take the money out of my account and put it in their account to pay my bills. They would have to pay it from my account. They would have to disclose that they were not me, that they were my agent. They would have to keep records, and they would have to do what was in my best interest. And all this language is in the power of attorney, and when they sign that document agreeing to act as my agent, they are signing agreeing to those terms. If they violate those terms, they can be held criminally liable for doing so. So that's some of the changes they did to the power of attorney. The power of attorney differs from the healthcare proxy in that you can have more than one agent acting at the same time, and that could actually be advisable. So if you have two parties that, maybe one's financially savvy and the other one has a lot of common sense, it may be worthwhile to appoint them both to have to act together. Now, if you have two individuals that you want to be able to act independently, you can do that as well. There's a little box that you initial that allows them to act independent of one another. There's many options. There's many boxes on the power of attorney. One of the important things is they added something called the gift rider to the power of attorney, and that is an expansion of basic powers to allow for gifting assets and opening bank accounts, closing bank accounts, creating and funding trust, items like that. And you may say, why would I ever want to give that authority for someone to gift my money? Well, it's not really gifting for the purpose of gifting. It is often used in elder law planning. And what we do is, so say for instance, we have a husband and wife, and husband needs to go into a skilled nursing facility, and we want to protect the assets, and namely the house. We may want to move the house out of the joint names of husband and wife just to the wife, the healthy spouse's name. Now, just because husband and wife are on the deed, the wife does not have the authority to transfer that house into her own name. If she had a power of attorney that authorized her to transact real estate and to gift, then she'd be able to do so as under the power of attorney for her husband. She'd be able to sign off for him. And the reason she needs gifting powers is if that house is worth over $500, the power, in order for the deed to be valid, being signed by an agent under a power of attorney, that agent would have to have the authority to make gifts. And by giving that half a house to the wife, that is a gift for whatever that half a house value is. So that's the power of attorney with the statutory gift rider. Years ago, they used to have a one-page form called the Blumberg form. They no longer make that form. If you did execute one of those forms prior to the change in law, which was 2009, it is still a valid form, and it's good for really simple transactions like trying to get someone's records, like banking or insurance matters or items like that. But it doesn't really allow you to do much more than that. But it is grandfathered closed in and still active. But if you signed a Blumberg form after September 2009, it is not a valid document. There are new power of attorneys. The power of attorney can be two ways. It could be valid upon the signing. In other words, you're able to use it upon execution. Or it can be a springing power of attorney, which is much like the healthcare proxy in that it only becomes effective if you become incapacitated. The, the difficulty with a springing power of attorney is you actually have to get a doctor to sign off on the fact that you're incapacitated before you're able to use, before the agent can use the power of attorney. And it can often be difficult to get a doctor to sign off on that form. So if you're doing a power of attorney and you're naming a spouse or very trustworthy children, it makes more sense to make it effective when you sign it rather than springing. That doesn't mean anyone's going to use it and you don't give up your authority to handle your own matters. It just adds the authority for someone else to help you with your finances or taxes or any other financial information. It also allows to get health care records. We put that in there as well. So those are the three directives that we often do in a basic estate plan, and they're extremely, extremely important. A DNR is only, people ask what's a DNR? Well, that's a specific instrument that says do not resuscitate, and that's cardiac resuscitation only, and they expire. I believe in the hospital it's 7 days or 10 days and they expire. In a nursing home, I think they're good for 30 days and they have to be renewed. And I'm not sure of the time frame in the home. But those are not legal documents and are not done, well, they're a legal document, but per se. But attorneys don't execute those. Physicians or PAs or nursing medical staff are the individuals that would present and execute that with you. So that's the DNR. So now we're going to talk a little bit about wills. It's very interesting because some people say, well, I don't have many assets. Why do I need a will? Everyone should have a will. The idea would be, obviously, to be able to pass assets without having to go to court and without having to utilize the will. A will only functions to distribute assets upon your death if the assets that you leave do not have a named beneficiary, do not have a joint owner on them, do not have a transfer on death clause on them. So for instance, if you own a house joint with your spouse, when the first spouse dies, you inherit the house without having to probate the estate because your name is already on the deed. If you have an IRA that names a child or a spouse and you pass away, they simply present a death certificate and they can collect those assets, much like life insurance and other items like that. Now, if you, in the first example, if you have a house that you own with your husband dies, and then you die, well, then there's no one on the deed, so that would pass through your will or through probate. I'll discuss what probate is in a few minutes. I just want to talk a little bit more about the will. So the will would name, obviously, who the executor is going to be, or who you want the executor to be. So actually, you're nominating the executor. The executor doesn't have the authority to act until the court says they approve and they're appointed, again, during the probate process. So you definitely would name an executor in the will. You would name how your assets, how you want them to be distributed. But more importantly, you would also put in other language that would protect someone from inheriting were they disabled. So you can put a special needs trust in a will. I put it in all my wills, and I basically have a trigger provision that says if any beneficiaries named here under inherit that are disabled at the time they inherit, then it goes into a trust for their benefit rather than go outright to them. And you actually can appoint who you would want to manage that money. The reason I do that is we don't have a crystal ball, and we don't know when we pass what condition our beneficiaries are going to be in. We could have a disabled grandchild that's mentally challenged. We can have a disabled spouse that's in a nursing home when we pass away. That, we put all the assets in our name and now we pass away, and our will's a sweetheart will that leaves everything back to our sick spouse in the nursing facility. We don't want that to happen. But if we have a trigger in the will that says if any of my beneficiaries is disabled, then that sick spouse isn't going to get the money outright. It's going to go into trust for them. And it could be used for them, but it's not going to throw them off any benefits they're receiving. So that's a really important provision to put in a will. The other reason you would want a will is if it eventually gets left to grandchildren or minors, or if you have minors when you prepare your will, you want to dictate the age in which those children inherit the money. The legal age in New York is 18 years of age, and that is way too young these days. We normally, at minimum, make them age a majority, that they would get it outright at 25 in the will. And you can dictate who would manage that money for them. So I'll give you an example, because you may say, you know, I'm going to leave it to my adult kids. I'm not leaving it to my grandchildren, and all my kids are over 25. Why would I need a minor's trust provision? And the answer to that is because if you have in your will that if one of your children passes, that you want their share to be shared amongst their children, then it's very possible their children are going to be under the age of 25. So we simply put that provision in there as well. Some other things you can do with your will is you can do tax planning. You can disclaim interest in estates to go into trusts. It gets a little more complicated for survivors, but to avoid estate taxes. A lot of people say, well, what is my liability? What are the estate taxes? Well, in New York, they're well over $5 million for each person. So that means I can leave $5 million and change. It's like $5.5 million with no estate tax to my beneficiaries. And the exemption federally is over $11.5 million as well per person. So for many of us, it is not an issue, the estate tax. Some it may be. But we don't know what's going to happen in the future. We don't know when we have a new president or when the law sunsets, you know, where we're going to be at. It wasn't so long ago that the exemption was $1 million. And while $1 million sounds like a lot, if you have a house and an IRA and maybe a life insurance policy, well, guess what? Your estates could very well be over $1 million. And if they do reduce us back down at some point, although I don't foresee it ever going back to $1 million, but there could be estate tax issues. So there are ways to plan in your will for that as well. So that's the last will and testament. And why I said we'd discuss probate later and the executor is merely not a nominated executor is because what happens is when someone passes away, and if they have assets that need to be probated because there's no beneficiary on it and there's no way for anyone to collect those monies, what happens is a petition has to be filed along with the original will and the death certificate with the surrogate's court in the county in which the person died or owned real property. And people have to be noticed that the will was filed and that the proposed executor wants to be appointed. And then the court has to approve the appointment of that person, that individual, that nominated executor. And once they do, then they issue something called letters testamentary. And those are letters that you would present to the financial institution holding the assets that you need to collect. So the word letters testamentary, a lot of times people will call a financial institution and they say, you need to get letters testamentary and we'll release the money. And I'll get the phone call, can you write me a letter of testamentary? It's not, it's actually an official document from the court. So who gets notice? So the people who get notice in a will is anyone that would have inherited had there not been a will, and any individual named in the will. So what I mean by that is, if you're disinheriting someone, you may not want to leave your assets through probate because that person is going to get notice that you're disinheriting them if they would have inherited had there not been a will. So I'll give you an example. I have an older gentleman that lives in Manhattan. He was never married, has no children, and he wants to leave his assets to mostly charities and a handful of great nieces and nephews. Okay? but he has tons of nieces and nephews through his lineage. So what would happen is, if he died without a will, it goes down the bloodline. So it would go up to the parents. His parents are gone because he's 99 years old. And if his parents are gone, then it would go to his siblings. Most of his siblings or all of his siblings are gone. So then it goes to their kids and their kids' kids. So you could see how this class gets very large. So I met with him and I reviewed his family tree, and I said to him, you're leaving a lot of people out of your will that would have taken had you not had a will. If they're going to be upset by this because some of your nieces and nephews are inheriting and others aren't, you may want to create a trust. If you create a trust, it does not go through the court system and they won't be entitled to notice. The only people that will know about the trust are the people that are benefiting from the trust. So that is the plan that we're going to move forward with, because the beneficiaries that he's not including in his will, his nieces and nephews or grandnieces and nephews, would be entitled to notice, and they can then appear and maybe object and say, well, he's 99 years old, our other cousin, unduly influenced him. And it could just really hold up the estate and drag things out. So in that case, we may want to do a trust. So I'm going to very briefly talk about trust because I think I only have a half hour and we're already well into 20 minutes. But there are things called trust. So there are living trusts and there are testamentary trusts. So when I was speaking about the trigger provision in the will for a minor's trust or supplemental needs, special needs trust earlier when we were talking about wills, those are testamentary trusts. Those are trusts that are in the will and are only created if necessary at the death of the individual, if the trust is needed, if there's minors or if there's a disabled beneficiary. A living trust is a trust that you establish during your lifetime, and you fund them during your lifetime, and they manage whatever assets are in them while you're alive, and when you pass away, they're distributed by whoever the then acting trustee is. So it avoids probate if you retitle the assets into the trust. So I'll give you an example. You create a trust and you have your house, and you're single, and when you pass that it would have to go through probate, all right, through your will. So instead, you create a trust, a revocable trust or an irrevocable trust. Once you create that trust, you actually have to retitle the deed into the trust. So what that is just like you got the asset, you did it by deed. Well, you're going to take that deed and transfer it from you as an individual to the trustee of the trust. Then the house is in the trust. You do the same thing with bank accounts, where the bank accounts are in someone's individual name. You would transfer them into the name of the trust by filling out forms. So there's two different types of trusts I'll speak very briefly on today. One is a revocable trust, the other one is an irrevocable trust. The big difference being is revocable trust you can create, you can manage as trustee, you can change, alter, do anything you want with that trust during your lifetime. When you pass away, whoever your successor trustee is that's named in the document takes your place if you're the trustee, and is able to continue managing those assets, paying your bills, and then distributing them to whoever your beneficiaries are. So that's simply put. When would you want a revocable trust? You would want a revocable trust if you wanted to avoid probate in general, which, on Long Island was not such a big deal prior pandemic, but with the pandemic, the courts have been closed for over 2 months. You cannot probate a new matter right now, so it's really been a burden for some estates where people have died and the family can't get access to the assets right now. So in this case, trust would really have helped that. If you're disinheriting someone and you don't want them to be noticed, you would want a trust. If you own property in more than one state, so if you own property in Florida and New York, you'd have to probate property in every state that you own dirt, per se. So if I'm a snowbird and I own New York property and I own property in Florida and I die, my relatives or my kids are going to have to do a probate in New York to get control to sell the property here. Then they're going to have to hire someone in Florida to do a probate in Florida in order to get someone to sell or have access to the property in Florida. So it can be very expensive and very time consuming. Instead, if I had a revocable trust or an irrevocable trust and I retitled the Florida and the New York property into those trusts, when I died, my successor trustee has the authority to sell the property or distribute the property in any way I had directed in that document without having to go through the courts in both states. So let's talk for a minute or two on irrevocable trust. And basically in my practice, I use irrevocable trust for protecting assets for purposes of long-term care. So we put houses and sometimes assets or life insurance policies into irrevocable trusts in order to protect them for purposes of Medicaid planning. So it takes 5 years for assets that are transferred into a trust to be protected for nursing home care. And currently, it's only a 1-month look back for assets transferred into a trust for home care. That is about to change. In April, New York State passed new legislation that puts a 30-month look back for home care. So it means that once you transfer assets to become eligible for home care, it's 30 months before they're protected or you're eligible. Nursing home care, it's 60 months, so they did half. An irrevocable trust you can create, but you or your spouse cannot be the trustee of that trust. One of your adult children can be, a friend, a sibling, anyone else, but it can't be a spouse or yourself. So you're giving up control of the assets you put in the trust. So you may say, why would I want to do that? Well, if you put a house in the trust, you still get your exemptions, you still have the right to live there, you still pay the bills, and you still maintain the property. So nothing really changes. And the beneficiaries of the trust, which may be your children or whoever when you pass, have no rights to that property until you're gone. So putting a house in an irrevocable trust is a great way to protect it and protect a significant portion of your estate for long-term care purposes without really giving up control. However, when you put liquid assets in an irrevocable trust, such as a brokerage account or a bank account, you give up the ability to take principal out of those accounts, and you are only entitled to income. So we don't put all assets in an irrevocable trust because while we want to protect some assets for long-term care planning, we don't want to tie our hands and live in fear, and we want the autonomy to do it as we like. So we may put a life insurance policy that has a large cash value or a portion of assets in the trust, or perhaps an annuity. Retirement funds are exempt for purposes of long-term care or Medicaid as long as they're in payout status. So you never would retitle or put a retirement fund in any type of trust because it has to be owned by an individual, and if you change the ownership, you would have a taxable event and have to pay income taxes on that. So you would never retitle retirement funds. So that's why public policy, they made them exempt. So there's a big difference between revocable and irrevocable trusts. When we do irrevocable trusts, it's really more for Medicaid planning or long-term care planning. Now there are other irrevocable trusts that are used to get assets out of the estate for estate tax purpose planning, but that's a topic for another day. So as I said, it is extremely important to get your estate and your affairs in order. You're never too young and you're never too old. Like the gentleman I spoke to at 99, he's finally deciding to do his documents. And if you have any questions at all, please feel free to reach out to me. I hope that you all stay safe and healthy, and that we're all back to some form of normalcy in the very near future. I really thank you for your time, and I can't believe how fast it has come. If you would like me to do another program specifically on trusts or another topic, please let myself know or let the library know, and I would be happy to do so. Stay safe. Bye-bye.